All right, welcome back to the House Judiciary Committee this Wednesday afternoon, April 22nd. We're continuing our consideration of S-193, and we have Jared Bianchi on the Zoom to go over our latest draft, number 2.1. Jared, thank you for being available on such short notice.
Thank you, Mr. Chairman and members of the committee. I apologize for my limited availability. It's spring break, so I have to be present for other family members.
Understood. We have that issue with many of our members as well.
So I guess I'll begin by saying I see a lot of edits here that are really looking to bring the victim's voice into the role. Into the fold and into consideration. So as a general matter, we think that those are strong and appropriate changes to make. We did have, and I believe Domenica Padula will be talking with you soon. I believe that she will be making some suggestions for, I believe 3 changes. We also believe that those will be appropriate. In particular, in the section on competency restoration and hearing, there is, I think it is on page 2. Domenica will have the notes probably more at hand than I will. That on page 2 in subsection 3A, that instead of saying that the court will notify the state's attorney and the person's counsel in the criminal case, it should say that the court shall order the person returned to the status that they were in prior to being admitted to the facility. So, in other words, if the hold without bail were in place, that person would be returned to that status or whatever their pre-forensic facility status was.
So, order the person returned to the status they were in prior to the hearing?
Yeah, custodial status, something like that, yeah. The federal statute also directs the court to set a date for trial. I think that could be a beneficial inclusion here as well. The piece on competency and restorability would benefit from clarity about specifically kind of what the test would be. And so Domenica, I think, will have some language from the federal statute. And we would propose adding a definition of restorable to competency, or whatever the turn of phrase is in the statute, based on what the federal statute says. And in brief, something along the lines of adding in section 4 of the bill, a definition for competency can restored, meaning shall mean that a substantial probability that in the foreseeable future, the person will attain the capacity to permit the proceedings to go forward. And that's taken from the federal statute.
And is that language that we're going to get sent?
Yes. Yep. I'll send it by Eric or Domenica will, or both of us will.
Okay.
I also believe that Domenica will be proposing, and we would support, inclusion of a victim's notification and input provision for the provision concerning dismissal of misdemeanor cases after a period of time. See no problem with that from our perspective, and even though they are misdemeanors, those can sometimes be very serious interpersonal cases. So when the court is assessing whether or not it's in the interest of justice, that feedback would be, at least the opportunity for it would be, I think, a benefit to everybody involved.
Yep. Okay.
We do see an opportunity here for a conversation around restorability, instead of having it be the second or subsequent, being essentially, not having that lead time.
So can I ask a question about this? And this will be for Domenica as well. Is something I suggested we look at, and that would be actually one of the 4 criteria for sending a person to the forensic facility in the first place. That's number 4, has been found not competent to stand trial. Why not right there, has been found not competent to stand trial and likely to be restored, or something along those lines? Why can't it be right from the get-go? Because there will be people, presumably, that they're just not to be restored.
Well, keep in mind a couple things. One, that the structure of this is so that even if they can't be restored, there is a process for public safety based, even community release and other opportunities. So it's not simply if you can't be restored that you would not go into the facility in the first place. That there is a structure for supervision based on treatment need and as well as public safety. Also, there's no way to know that at that stage. There have been no assessments done for that purpose. And so without really opening up a much broader swath of statutes and reimagining sort of the competency process from soup to nuts, which was, I think, really the intention was not to do that. I think that would be premature. It is consistent with the federal statute to have there be an initial assessment that would address that. I think this would put us pretty close to what the federal process is. And so we were going to say, we see that was a reduced timeline. At this juncture, we're not going to raise particular objection to that. But I think going much more precipitous than that, much more quickly than that, would be problematic from a couple of respects, because the determination wouldn't be based on sort of an ongoing clinical sort of assessment of that question. There would have been no attempts to create a regimen of competency restoration. And that would also, if you were to put it right up front as a forensic facility sort of gate, if you will, if you were to do that, then you would also be missing the opportunity for even that population to be addressed through the forensic risk assessment process that's set out here.
Okay.
And so
Yeah,
for all those, go ahead, sorry.
Yeah, no, I understand that makes sense. So I guess the next question that I would have with respect to the same issue is allowing, and I'm looking on page 2, line 5, 6, the determination of the forensic facilities clinical services director that the person is likely competent to stand trial or is not restorable. Allowing that earlier if the services director determines they're not restorable, that can be before that 6-month check-in.
I think given the nature of the cases that we're talking about here, and given because I mean, again, this is not everybody. This is a very specific population. I think before we open that up, I think given that we are only talking now about a 6-month period, I think that's sort of an inherently reasonable period. I don't think that we need to expedite that further in the context of a person who is already going to be subject to a hold without bail in all likelihood, and who really we're talking about a brief deviation to make a real assessment of the person's risk and suitability for competency.
Okay, all right. Appreciate that answer. Ian.
I was just going to push back a little on the point that there hasn't been an assessment yet when we're kind of thinking about whether to amend the language on line 1 on page 2, because my understanding is that they will have already gone through the full competency hearing, right? So there's been a full evaluation, and they have had the forensic evaluator pursuant to that other statute, and there can be basically a determination at that time, right?
So I would suggest that would not be the case, because there is no provision, again, without sort of opening up the chapter more fully to other revisions. There's no provision that would include that assessment, and it would also be necessarily not informed by the people who would be dedicated to looking at this in the forensic facility process, and charged with coming up with that plan of education. And because you're really looking at not one specific type of issue, right? This is not just mental illness, or not just it's a broad set of qualifying conditions. The scope of people who would be really called upon to look at that is a much broader scope of people than would be doing these just the vanilla competency evaluation that you get pre-trial for any number of cases.
And then just one other question, Jared. Do you think that we need to just looking at the rest of that chapter, if there are things that we need to change, just because it's all around competency evaluations right now, in one type that currently exists, but now we're adding in this new version of it, and it's done by a different entity. Like, is it going to line up well enough for in actual practice for practitioners who are going to be maybe doing competency evaluations that don't involve the forensic facility because they aren't qualifying, but then they might have some that are? Like, is it going to line up?
So the hope was yes, I think when the language was being developed, but a couple parts, yes, but how's that?
Okay.
I think that they line up well because you'll see that the structures here are new sections that build off of the existing competency or not guilty by reason of insanity for a specific class of defendant.
Yeah.
So they are building off of those pre-existing concepts. The bill already talks about allowing basically a statewide contract for evaluations. So I think that will help bring about consistency. That basically the people who are able to or need to be able to pull down these sorts of services can do it according to that BGS contract once that's in place. We had suggested language, and I think it just didn't. I didn't get the sense that there was any concern with it, but I didn't see it come into the last version or two, where we did want to clarify. Right now by law, any party after there's what we call sort of the neutral evaluator, either party can get their own evaluation done. That's also true for competency evaluations, but because this is creating what I'll call two different kinds of evaluations that we have not had access to, a paragraph in here allowing that same access by other parties to get their own evaluation of the forensic risk assessment, as well as the restorability component. We would need to have language like we have for the competency evaluation to be included for those new evaluations.
We just mirror the language that's in 448.15 or wherever it is.
I think yes. I think so. I don't have it up in front of me right now. I apologize. This is sort of last minute. We had proposed language, but yes, I think you could accomplish the same thing by mirroring that, so long as you're clear that it applies to those new evaluations that are going to be created by S193, however you want to do that. But because right now everybody has the ability to get a competency evaluation, it is almost certain that we're going to be. I think having that clarity right up front will avoid a lot of unnecessary litigation. Just that the parties can get their own evaluations for those hearings as well.
And then just one more. So looking on page 2, so I'm just thinking about how these hearings that are going to happen every 6 months, do we need some kind of timeline for the disclosure of the competency evaluation? Do we just let me ask a couple of them. So you can just timeline for the disclosure of the competency evaluation. Do we need something that compels the evaluator to be there, so that they are a party, or if they're not a party, they're a witness at the hearings? I'm just thinking about if these are subcontracted people outside of the state, like how they actually are part of the hearing, or do they even need to be? And then do we need to set a timeline for when the disclosure happens to when the hearing happens, so that there's sufficient time for those additional experts?
So I think if it's not in this version, I could see a benefit. Act 248 right now has a provision that says basically that the commissioner or their designee shall testify or whatever. I think that something like that would be good. There is a provision that allows for video testimony in this bill, and I think that will go a long way to making that easier. I wasn't sure if we had addressed that in this version or not.
No. The remote, yes.
Okay.
That would apply to these hearings too.
We'll double check.
And so I think in terms of the timeline, my read was that, if it's not sufficiently prompt or enough time before the hearing, that the court could continue the hearing for a later date and would be able to make that assessment. So because I don't know how long it's going to take to get these. I kind of was thinking that that would be something that would be addressed on the particular facts of the particular case.
Yeah.
I wouldn't be opposed to something like that, but I also would want it, we might, getting into what's reasonable under the circumstances might differ from case to case. So that would be, I think that's, the ability to continue the hearing for good cause, I think sort of addresses that. And that's, stating that insufficient time to receive or be prepared would be good cause could give additional heft to that if need be.
Okay.
But yes, I think if there's a provision that says basically that the evaluator and the clinical director, shall testify if requested, would be fine.
Okay, yeah, go ahead. I think we started asking questions before you got through what you were going to weigh in on.
That's fine. I understood just in talking with Attorney McManus that there had been a conversation about whether for the not restorable population there should be a periodic hearing. The way that I have read this, or at least that I was intending for that we were hoping, is that I think that yes, even if the person is not restorable, there should be a periodic hearing. We have an annual hearing. If it is not currently sufficiently clear, that hearing should also apply to people who are not in the facility but are subject to conditions. I think whatever the degree of oversight, if they are being subject to court conditions, there should be that periodic review. It's a little bit more confusing in the non-competency section because the NGRI people are going to be subject to some degree of supervision, so they're all taken care of there. But where we've mirrored the language for the not competency, not restorable people, if there's any question, it would be my position that an annual review should be applicable to everybody, even if they are out but on conditions. That makes sense.
Right. Okay. And there was another question I forgot to ask you that's on page 1, and that was in the subdivision A3. And I asked Dr. Bowen this, and she agreed that if the person is either hospitalized or is under Dale's is committed to Dale under Act 248, it's kind of the same kind of result.
So I would not make that suggestion. I think that the issue here is to avoid a person who requires hospital level of care, to ensure that they are able to access that hospital level of care, because this is a subacute sort of a facility. A person who is on Act 248 is and otherwise not subject to a hospitalization order, it does not require a hospital level of care. So it's two different issues. I don't think this is not a question about whether they're in the custody of another commissioner. It's the question of are they too acute for this facility?
All right. Okay. All right. Did you have anything else? I know that you don't have that much time left. But...
No, I think I've gone through that pretty quickly. So I apologize if it was too quick. We see these edits as being beneficial in allowing us and giving the ability to have interface with the victims on these types of cases. It's something that we have wanted for some time to be able to more fully involve them. Just one moment, please. On page 17, and I think the first time I testified, we had a conversation about the state's attorney being able to keep the victim informed, not to provide copies of records, but to keep the victim informed of their understanding of what was going on with the individual, the defendant. I would say if the intention here is to take the victims out of the dark, that would be a big piece, because right now I think victims don't have any sense of where somebody is, what their status is, how they're doing. And we, even if we do know, really don't have an avenue to tell them. So allowing allowing some not to provide records to the victims, but to discuss information with the victim as for instance, to inform their ability to make useful comment to the court at these hearings would be helpful.
Can you suggest some language, send us some language that would accomplish what you just suggested?
Yeah. I'm just taking some notes. I apologize. So other than those comments, I don't have any other comments. I think the committee has struck a balance with wanting to make prompt assessments of restorability, but giving appropriate time to do that by shortening to the 6-month window. I think that's relatively consistent with the federal provisions. So, we see this draft as a progress and just make those suggestions. Thank you.
Great, thank you, Barbara.
So I have been trying to see what the norm is for the person's commitment being reviewed. And every 12, there's no other state that does every 12 months. Most of them do much shorter than that.
So in which context? Are you talking about for the competency evaluation context?
Yes.
Okay. So I think that there, at least the federal government, which is, we have the benefit of some decisions and whatnot if we build off of sort of that kind of structure. It talks about there's basically no set timeline that must be adhered to in the statute. There is an initial review that's done, I think, in 4 months, but it allows the court to set basically what the court deems to be reasonable under the circumstances for competency assessment, and not just assessment, but returning a person to competency. So, I've also heard, I think through General Valerio's testimony, that there's a much longer time period for people, like for instance in California. I think that this is an appropriate balance between those competing factors.
I mean, the other thing that seems like an outlier is progress reports every 6 months. It looks like the norm is somewhere between 30 and 90 days for most states for judicial review of progress made.
Yeah, I don't have that data. If that's something that you have, I'd be happy to look at it. Again, just returning to the federal piece, there's no set timeline. So if we're talking about competency evaluation every 6 months, that's pretty consistent with existing practice. Even if a person is held without bail while we're having this fight, that it takes time both to hire, to review records, to get the evaluator in there. But in that same time frame, they're not having the opportunity to actually provide the services to return the person to competency. Right. And so, especially in the sorts of cases that we are talking about with this bill, which are only the most serious offenses, this is going to, I think, frankly, even as it stands right now, is a considerable amount more due process than is necessary. It also places, I would be clear though, it also places a much higher burden on the state than does, for instance, the federal statute. So that's another consideration as well, is that while we may deviate here or there, the burden structure and the degree of burden is distinct.
It's interesting because I was thinking, in addition to if it would be a problem with Jackson v. Indiana, because it seemed like that was referenced a lot. It's more also from a treatment perspective. Having worked in long-term and short-term treatment, sometimes providers are like, oh, we don't have to do we're reporting in 6 months, so we can get to this person. It sort of takes the pressure off of either sometimes to be actively working on a case, where if it's like, I've got to go into court in 45 days. I don't want to go in and say we didn't do anything.
So the only thing I would say to that is the defendants, especially in Vermont, have a lot of protections. They have a lot of protections beyond even many other jurisdictions. And so what Jackson is worried about is a person being held solely on the basis of dangerousness. What we have accomplished here in the draft that's before you does not offend Jackson because it requires both dangerousness and a qualifying condition. And if the person is not restorable, then there is that sort of more typical civil process that they then go into. So Jackson was offended by the notion that the person could be held essentially indefinitely only on the basis of the competency restoration without that civil process. This bill does have that process that then attends to that population.
All right, thank you, Jared. I understood that you had to be gone at 2:30, so I think we're right on time.
Thank you, and we will send along some suggested language. Have a wonderful day.
Great, thanks a lot. Dominica, if you could join us. Thank you for being here.
Domenica Padula, Chief of the Criminal Division for the Vermont Attorney General's Office. Thank you for having me. What Jared said. So when I talked this morning, I kind of went through everything to kind of, say, the committee spent so much time and sometimes it feels like we can just go around in circles about what is helpful to kind of pull out to talk about things. And Jared referenced a few of those points. And I think maybe that hopefully will be the most helpful. Where he originally was talking about, if that's on that page 2, line 10, and that's talking about the procedure of once a person is found competent by the court to stand trial, then at that point, it should, right now, it would be the suggestion of taking out from the comma, the court shall immediately notify the state's attorneys. I mean, we would have already been there. And I apologize, I wasn't able to listen to this morning's testimony. So if I'm repeating something that someone already brought up, I apologize. I think kind of the recommended language would be that then the court orders the release of this person from the forensic facility and that they should be restored to whatever status they had before they were remanded into that facility. Whether that was a hold without, whatever. I mean, when we're talking about a very specific subset, I think if we were talking about all cases, then it would be different. But I think we're talking about mostly you're going to talk about a remand back in a hold without status.
Right.
So that's very helpful.
Yeah, and if you could send a language
Yes.
suggestion on these things, that makes it easier for you. Make sure we get it right.
Great, and that would be great. And then again, referencing, so in this, we know how to do a competency hearing. We know how that happens. We do them pretty routinely. Creating this restorability piece is the new piece for us. And so when you have a word or a phrase, and this is page 3, line 1, we're talking about on whether the person's competency can be restored. That being a definition as the federal definitions have, and that definition is just means shall mean a substantial probability that in the foreseeable future, that this person will be able to attain the capacity to permit the proceedings to move forward. That would be the definition. How case law develops about what that looks like is finders. What is beneficial about relying on something like the federal process is that we are going to need to hire people who know what this means and who are really knowledgeable and can talk intelligently about this standard and not just guessing at something new that we're creating. So it's very important, I think, for due process for everyone to have professionals who are used to this process and used to this language being able to opine on that so that the court can make a ruling that's appropriate. So that would be the ask of that being put into the definition section of that. I think the other important thing, I'm not sure if Jared did bring it up, but on the same page 3, talking about line 9, So this now moves into a different hearing, right? If the court finds that the person's competency cannot be restored, and we're on the other side of that restorability competency piece, that the court shall hold a hearing within 60 days unless that period is extended. We keep using the word hearing and hearing and hearing. It would be nice, I think, and I'm not sure what the right term should be, but if that's the forensic risk assessment hearing or whatever that is, to really clarify what hearing we're talking about in that section, so that it's clear that we've now moved past competency, we've moved past competency restorability, and we're now in another hearing. And that hearing is whatever you'd like to call it, the risk assessment, where these other mechanisms start to play in. And then also hearing the victim testimony from last week, it's still with me, hearing Emily's testimony. And it is so wonderful that victim notification and victims' voices have been woven in to these places that are untraditional, but really, really needed. And our additional ask would be, even though we are not focusing on the vast number of cases that are affected by competency and other kinds of things, there is mention here about the misdemeanors. And there are some, misdemeanors that impact people, and even things that you think wouldn't impact people. People are impacted by crime, and they're impacted by trauma, and they're impacted by things that happen to them. And, it's very disorienting to just have a case done and then all of a sudden get a phone call. Well, they're not competent. The court just dismissed this. But they then have not their day in court, but their say in court. And it's just different in that way. That if the court is going to take this step, and if they're going to do that, this will be the only time that a victim or victim family will be able to have their say to the court. And sometimes that's a step towards healing and reconciliation and kind of what is happening to them through this process too. And that the judge can hear how something has impacted and that be a part of their decision-making when it comes to that. So that could help a judge decide that piece of contrary to the interests of justice. And even if they somehow don't think that, families and victims will be in the courtroom to hear the rationale and the reasoning of that. And sometimes I think, they wrongly think that judges don't really consider this, or what were they thinking, or was it just something that they just decided on a whim? And that's usually not the case. I mean, judges throughout the state really take their job seriously, and they wrestle with the same things as everyone else. And I think it will create a good opportunity for that exchange, even on the misdemeanor level, that would be something that could just mirror how those provisions were in the other parts of this, that would be reflected in that competency stand trial determination on the dismissal. So those were the top lining specific things to draw your attention. Otherwise, we remain very supportive of this bill.
And do you have victim notification language you can suggest as well when you send that?
Yes. And my thought would just be mirroring it on like page 5 of, again, that you provide, the state attorney can provide the victim with notice that this is coming up, that this is substantial, that hearing, and mimic that language.
Is that done in a hearing?
Well, it's going to be something that, if it's a contrary to the interest of justice, whether that is something that would be on motion, or if it's an on motion, then we could have victim advocates assist us in kind of what they do with victim impact statements or something along those lines too. But we would envision that because of this, there would be at least an appearance of that case, and that could be either at that time, or we could do it in advance.
Yeah, I'm just wondering if this is the kind of thing the court would just. Okay. I think I understand that. But it's the language just isn't necessarily really clear that there has to be any kind of hearing.
And however, we can certainly work with the network or other victim advocacies to try and figure out what might be appropriate in there, having either a bifurcated definitely, or that it requires a final appearance in the court before this is decided.
Right, okay. Yeah, I mean, there's, I'm just kind of seeing some complications, like a lot of the misdemeanors might not really have a victim. And all right, so we'll just have to work on that a little bit more, so. But if you can provide recommendations.
Sure.
Any questions for Domenica? All right, no, I think we know, I think we have enough to go on for version 3.1. I didn't capture everything that you were catching when you were talking to Jared, so counting on you to.
Noted that.
What we need to do on that one, I think I zoned out for a moment. Or I was distracted by text from Karen or something like. So,
That is Karen's fault.
that's how he is.
It's Karen's fault.
Kim, did you want to say anything? Did you want your turn? Oh, no.
We just note for the record, the spreadsheet.
Yes, it's,
Sorry.
yeah, can you do a walkthrough of your?
She hand drew every one of them. There are copies.
So it's very nice. So we'll somehow get this scanned and put on our. Put on the web.
Great.
Can you sign it for?
I think that happened.
Yeah. All right, so turn 1 of 11. All right, so just tomorrow morning, we're gonna do 208. Should I do a vote right now? Do we miss anybody for 410? We can do it tomorrow morning. Kenny is here, and maybe we'll get Alicia. We already had it's back with a proposal of amendment. That's the recidivism and studies that we're having CRG do. And we went over the proposed amendment on Friday, sometime Friday, I guess it was. It's very straightforward. It's like we can remind ourselves when we take the vote, but it's going to be on the notice calendar tomorrow. And you'll be ready to report that.
It's notice
It's
calendar
not
today.
notice today, I'm sorry, it's on action calendar tomorrow.
And Alicia got so many interrogation questions that you should do something else.
Oh, yeah, you're gonna have to work a lot of these. Yeah, why don't we wait until tomorrow morning when we have so it's not a 7-0. But I'm assuming it's gonna be, everybody's gonna be okay with this. Simple change. We'll do that tomorrow. So we're doing, like I say, 208, there is a new version. I think it's either been sent around or it's posted. In the afternoon, we'll have a discussion, although we have Todd Delos just to address the Attorney General's one paragraph in 209. And then we'll have a discussion on what to do next with 209. And then we're going to hear just a kind of introduction to the to the relinquishment study group and their recommendations. We won't get into the actual language, though tomorrow we'll just get an introduction to that tomorrow. So we're adjourned till